Hello, everybody. Hi, making sure we're live on all our social medias. Just give me 1 second. We're on TikTok, Facebook, YouTube, and Instagram. Yes, we are live. Okay, perfect. Hi, everybody. My name is Attorney Michelle Perez. I am one of the founding attorneys here at Saavedra Perez. I'm here to answer any immigration-related questions that you have. We're here every day on lives to answer any questions that you have regarding immigration, regarding us, our process. Any questions that you have, you can ask. I know the big thing is the keeping families together, Biden's parole in place. And so there's been a lot of questions recently on lives about how that's going to turn out, what's the effect. So we're not exactly sure what's going to happen in October on the next hearing, but we are getting a lot of information about just basically what's happening. Questions about general or about the families together, you can definitely comment below and I'll be able to see your comments, whether it's TikTok, Facebook, YouTube, or Instagram, and I'll be able to answer those questions for you. Again, my name is Michelle Perez. I'm one of the founding attorneys here. I do lives on the Fridays, and Isabel's here Monday through Thursday doing lives just to kind of inform the community of what's going on, to be able to be here to answer any questions that you may have. So definitely ask. También hablo español, pero mi primero idioma es inglés, pero si tiene algunas preguntas, me puede comentar en el comentario abajo y yo puedo tratar de responder. So very busy day for me. We had a good wins. Can't talk about, in detail, but we had some good wins today at the firm. So it's a great Friday for me. Been doing a lot of research for clients. What we do here at Saavedra Perez is we really try to personalize your case, because honestly, everybody's case is different. It really depends on your immigration history, and one little small thing can change what we're able to do for you. But our promise is that we'll be with you at every step of the way, and that we will try to provide the best legal advice that we can with the environment that we're in. Right now, we're in a Biden administration. We don't know what's going to happen in November, but we'll still be here providing assistance for immigrants in the United States, for any undocumented individuals. Just because Trump might win doesn't mean that all is lost. So I would definitely call us for a consultation to see if you're eligible for any type of relief. And meanwhile, while we're in the Biden administration. Okay, what happens? We have a question. What happens after the 3-year work permit if you're not able to adjust here in the United States? So with a work permit, it really depends on what you're applying under. If you're applying under a residency application and that residency application gets denied, then you are no longer eligible for a work permit. So it really depends on why you have that work permit. If you tell me the category of your work permit, I'll be able to tell you what your work permit is based on. The category is usually on your work permit, and it'll say category, and it'll say C or A, and it'll say 09, 18. And that'll tell me more information about why you have that work permit. PIP with the bar. So that's for the new parole in place, for the keeping families together. So we honestly don't know. We don't have any instructions about if it's renewable or not. We are assuming that it's not going to be renewable. So once you finish with those 3 years, getting that Biden, that work permit under the Biden parole, you're kind of left in limbo. So the hopes is that Biden parole gives you what you need to continue with your residency. And with your residency, you need a parole or a lawful admission in order to continue with your residency if you have a basis behind that, right? So you would be married, usually in the circumstances of the Biden PIP, you're married to a U.S. citizen, and so you can continue with that under your residency application. How can I contact you to start a residency application? That's a great question. You can call us at 571-583-0791 and ask for the, you'll see options and you'll ask for the consultation team, and they will be able to set you up with a consultation, whatever's free on the calendar. So call us for a consultation, and then we can evaluate your case to see if you're able to apply for residency or what you're able to apply for, okay? Will you get deported? They're saying that they're not going to issue people a notice to appear, but do I believe them? I mean, you can't really trust the government 100%. So there's some caution about applying for the parole in place. If you're not eligible to move to the residency, to move to a residency application and just stay with a work permit for those 3 years, they're telling us that they will not issue you a notice to appear. A notice to appear is basically charging you deportable and then placing you in front of an immigration judge to get you deported. They have to go through that process if you're in the United States. And if you've been living here for more than 180 days. So they have to put you in deportation proceedings. So it's not like they put you on a plane the next day. You have to go through court and they have to show why you are deportable. And if you have relief available, then you can apply for relief and with the court or outside the court and show the court that you have something pending, and they will either dismiss your case or terminate it or adjudicate whatever application you have in front of the judge. So we really don't know for sure if these individuals that finish the 3 years, and are they going to be placed in deportation proceedings? We really don't know. We don't know who's going to be president in 3 years. We don't know who's going to win in November. So all that are variables in how immigration operates. Immigration laws really depend on who's in office and what kind of policies they bring down or what they stop, right? So DACA was huge when Obama was here. Trump stopped DACA, and DACA applicants can only renew. You can't submit a new DACA application. So that's the same thing. Possibly that could happen if Trump wins again. He can stop this Biden parole completely. And so the people that may have been able to apply won't be able to apply if he does win. Okay. Is it free? No, our consultations are $50. They're only $50. It could be either in person if you're in Virginia or Clearwater, Florida, or virtual through phone or Zoom. We try to, if you're in person, like definitely come see us in person. If you're not in Virginia or you're not in Clearwater, Florida, then we do Zooms. We encourage Zoom because we want to see your face. We want to get, for you to see us and see that we're real. I know with this virtual world, it's a little different, but we definitely want to be able to connect with potential clients that would want to become clients. So we encourage Zoom consults, and your consult's always going to be with an attorney, either Isabel or me. Normally Isabel, she works on the consultations and I work on our current clients, but I do consultations here and there in the Clearwater area. Okay. How fast will the process be after submitting the application? Does it all depend on the court? Yeah, Liz, it really depends on the courts. We don't know what's going to happen. Consultations that we've been having now, we encourage people that we don't know what's going to happen in October. We're going to warn you, right, that you can potentially lose that 580 which is the filing fee that you filed to do your Biden parole. But that's just a risk that some people are willing to take, some are not willing to take. That's really just your preference. So if they are thinking about doing it, I encourage them to do it now while they're still accepting applications. It could be, something that changes in the next couple of weeks where they'll no longer accept applications. So if you're thinking about it and you just want to make sure you're eligible, please reach out and schedule a consultation so we can see if you're eligible, what your risks are if you may be eligible, but they're what you call a presumption of ineligibility. So for example, if you have a removal order and you've never left the United States, or you were granted voluntary departure, but you never left the United States, you have a presumption of ineligibility. And so they want to, you need to show factors as to why you have a deportation order. There's certain factors that they list on their site, right? Lack of notice, ineffective assistance of counsel, meaning you just had a really bad attorney. There are different reasons: medical, physical, disabilities, any reasons that you can place on there so it can make your application look better than just I didn't attend and I have a removal order and I just never left, right? They want to see some reasons behind that. We'll let you know that. We'll say, like, this is the risk that you have. You want to apply, we can. This is your issues depending on your case and your situation. If you still want to apply, let's do it. But here are the risks, right? We always want to be honest with our clients. These are the risks associated with applying. And because the parole in place is a very new subject, we just don't know how it's going to play out. Okay. Okay. It's okay to feel very anxious about the process. Yes, it is very, the process, that's why we're here, right? As your attorneys, if you do sign on with us, we're here to try to be with you at every step of the way and calm that anxiety, because you don't know what's happening. We can give you what we know and what we know of the immigration laws and what we know of what's happened in the past. But the process is not easy, right? And it just depends on your immigration history. But it's very okay. It's very normal to feel anxious and nervous about the situation. Okay. If you're on TPS and have EAD, do you have to mention it when applying EAD through pending asylum? Only if they ask, right? So if you're on TPS and you have EAD, do you have to mention it when applying EAD through pending asylum? So when we submit asylum applications, if you have other EADs pending, other work permits, EADs are work permits, that's just a good government identification to show that your picture is who you say you are and that the government has verified your identity already. There's nothing wrong with applying for two EADs or two work permits under different applications. Nothing's going to happen. I always actually tell my clients that if they have multiple applications pending, then it's probably a good thing to have work permits pending under any applications that you can have. So for example, if you have a VAWA pending and you have residency pending with that VAWA and you get an EAD or a work permit based on that residency application, you will then once you get your VAWA approved, you will then get another EAD based on that VAWA approval. And even though you have two EADs at the same time, they're under different categories. But I always suggest that you keep both of those current, because you never know. What if they deny your residency application and you were always doing your work permit under your residency application and now it was denied, and so now you don't have an EAD or a work permit anymore. And same with VAWA, right? So you want to make sure that if you're eligible for an EAD under whatever application, that you continue to apply under both. Okay, we have a question on YouTube. Después de ser enviado por USCIS el permiso de trabajo VAWA, ¿cuándo lo recibo? Ok, con VAWA depende si usted tiene una aprobación de VAWA, puede conseguir un permiso de trabajo. Normalmente cuando hacen la aprobación de la VAWA, manda un permiso de trabajo el mismo tiempo, pero si usted tiene un VAWA pendiente, tiene que tener la residencia pendiente también, porque no puede buscar un permiso de trabajo bajo de VAWA, solamente en VAWA. Usted puede buscar un permiso de trabajo bajo de una aplicación de residencia pendiente. So, usted tiene que ver si ya mandó su paquete a USCIS, tiene que ver de qué category tiene en los formularios. Si dice C09, eso dice que tiene una aplicación de residencia pendiente. Si dice C, y eso es el único que puede buscar un permiso de trabajo bajo de VAWA. Tiene que tener la residencia pendiente con la VAWA. Ok, Diego dice, hola, tengo DUI 10 años atrás, ¿puede aplicar por PIP? Sí, Diego, puedes aplicar por PIP, pero todo depende en la situación de su DUI. So, el DUI depende del estado. Usted tiene algunos diferentes DUIs. Algunos DUIs son misdemeanors, son menos serio. A otros DUIs son aggravated felonies, porque hay un aggravated factor con ese DUI que dice que el DUI es más grave y más serio que los normales. So, tenemos que ver si tiene el DUI más grave o son misdemeanors. Pero son misdemeanors, eso no dice que no cualificará por el PIP. Solamente si tiene una felony, eso sí, y usted no puede cualificar. Y mi recomendación que no trata de aplicar por el PIP. Okay, my husband has a voluntary departure. Does he qualify? That's a good question. So for the voluntary departures, if they never left after having a voluntary departure, that voluntary departure turns into a removal order automatically the day after the last day for him to leave. So your husband does have a removal order if he never left. Now, what the regulations are saying under the Keeping Families Together Biden PIP is that if you have an unexecuted removal order, which is the case of your husband, if he never left after that voluntary departure, you have a presumption of ineligibility. What that means is that they're presuming that you're ineligible for Biden PIP unless you can show them some circumstances behind why he never left on that voluntary departure. So it could be that you had ineffective assistance of counsel. It could be that there was a lack of notice or that you weren't told of the day that you had to leave on that voluntary departure, or maybe COVID happened during that time and you didn't leave for those reasons. You were on lockdown. That's a great reason. Maybe some physical or mental disability. We would pack on depression, anxiety, anything that was happening during that time that could give them an explanation as to why there was, why you never left. So they're going to presume to deny you, but you would have to almost fight back. So we do take those cases. We've had a few of them. Obviously, this Biden PIP is new and it was recently paused, but you can still apply and we can see what happens in October with the next hearing. But usually what we would do, we would fight it as best as we can. We obtain all the records. We get all the reasons that they have and try to pack the case with reasons why there was an unexecuted removal order, why you didn't leave the United States, and tack on some good moral character to try to help USCIS to adjudicate despite that voluntary departure. But if you don't qualify for the Biden PIP or your husband doesn't qualify for that PIP, I would call our offices to see what else he qualifies for, because normally with these PIPs, if you qualify for the PIPs in some circumstances, you can qualify for the 601A 212. So if your husband can't do the Biden PIP and for some reason it gets denied, you would have to do 2 waivers. The first waiver would be I-212, and the second waiver you would have to wait for the first one to be approved would be the 601A. The first one waives the unexecuted or the removal order, right, that wasn't executed, and the second one would waive your unlawful presence after your husband's illegal entry. So those two need to be adjudicated before your husband would leave the country and then come back on after doing his interview at the consulate abroad. As long as everything is okay, there's only one entry that he has, and there's no like issues of a permanent bar or anything like that, he should be able to come back into the United States with his residency. But right now, those cases are taking, for those people that need like 2 waivers, right now the 212 is taking 30 months, right? And the 601A right now is taking 42 months. So it would be a very, very long process. Obviously, the Biden PIP would be a better fit. And what I suggest is we can try the Biden parole in place first. And if we lose that, then you have a second option where you'll do the 2 waivers. Okay. Okay, hold on. A few questions here. USCIS sent me a document saying biometrics were used. I went to biometrics many years ago. What do they mean? Antonio, that just means that they have your fingerprints in the system and they don't need you to come in to retake your fingerprints. So they'll just use your old fingerprints and they'll rerun your fingerprints in the system, see if you have any new criminal, or not new, but if you have any criminal arrests that have happened since you last took your fingerprints or your biometrics. If you're on TPS and have EAD, do you have to mention it when applying EAD through pending asylum? I think I answered your question, and it's, you don't have to, but immigration is going to see your record anyway, so they're going to know that you have TPS pending. It's always good to have multiple EADs or work permits if you have the ability to do so. You never know if TPS gets stopped or for any reason, then you have the asylum EAD that you can use. The reunion family can help with that. No, I mean, I don't know what you're exactly asking, and it depends what you're asking about. So Lino Perez, if you want to explain a little bit more. Can you help with EB-2? No, right now we don't do employment-based visas, which includes EB-2. Normally what I tell clients is like attorneys focus on one or the other, right? Because there's a lot going on with employment visas versus there's a lot with the removal defense and humanitarian visas. And so if you're practicing both, you might only be specializing in certain areas for business immigration and certain areas for the family portion, because there's a lot just going on the family portion. We focus on the family portion, which could include family petitions, naturalizations, deportation proceedings, undocumented individuals that have been here that might be eligible for humanitarian visas, TU, VAWA. We do help with citizenship, with maybe residents that have criminal concerns. Like I said, we help with deportation and appeals to the Board of Immigration Appeals. I have done a few federal court appeals, 11th Circuit appeals for removal cases. So we've done that. We've done a lot of appeals for 290Bs, which are appeals from USCIS decisions. So we do most of all of that. We don't focus on employment-based. But there's a great firm that we know in Texas, Villada and Garcia. We're actually going to be doing a live with them next week. I believe it was next week or the next couple of weeks, where we can introduce them on our socials. They're good friends. We really trust them. And their firm, Villada and Garcia, do employment visas. Should I appeal if my permanent status got denied and the next day my alien relative got approved? Yes, you can either appeal. Okay, I would want to see the decision for the residency application being denied. Or honestly, I would simply send them a letter so you don't have to pay for a 290B appeal, and ask them to reopen your residency application based on the I-130 being approved. But I would really need to see or want to see the decision for the residency. Was it based on a I-130 being denied or pending? That usually doesn't happen, right? Only if the I-130 alien relative was denied would they deny the residency application. Because for a residency application, you have to have a petition under that. You have to have a petition base. You have to have a reason attached to your residency application, whether it be a marriage petition, a family petition, under the Cuban Adjustment Act, because you're a Cuban paroled into the country and it's been more than a year and a day. You have to have reasons behind applying for a residency application. So I would want to see what that decision was, because if they find anything else that you may be ineligible for, that they will deny your residency application based on those. And it doesn't matter if your alien relative got approved. Your alien relative petition just means that you've established that you are in fact either married to this person or a family member of this person. Okay, hope that answers your question. I only have time for one more, but let me see. What is an employment visa? Employment visa is just a type of visa that you would get if maybe there's a job offer in the United States and you're outside and you want to come in with that employment visa. Some of them are temporary. Some of them can lead to residency. But that's a different type of immigration that we don't do here. We only do deportation, defense, family petitions, and citizenship. So undocumented people that are usually here. For employment visas, those are really just for people that don't have unlawful presence here and never had unlawful presence here, and are still outside the United States. For ULP perm bar, who is a qualifying relative for a 601 waiver? So for unlawful presence permanent bar, who's a qualifying relative for 601 waiver. So that would be your lawful permanent resident spouse or U.S. citizen spouse, or your lawful permanent resident or U.S. citizen parent, for the 601. You're not able to use your children as qualifying relatives. And really it depends on why you're seeking the waiver. So if you have a criminal issue and that's why you're seeking the waiver, then it's different. But your permanent bar, I would really talk to an attorney if you have an attorney, because the permanent bar can only be waived with a VAWA application, a VAWA application, and you have to connect the permanent bar, the trigger, to the abuse suffered by that U.S. citizen spouse or that U.S. citizen child over 21. Because that's the only reason that's the only way you really use a 601A waiver. You can't, permanent bars are not waivable unless you're seeking VAWA U or T visa. So I would really get with an attorney to see why you're thinking a 601 waiver is what you need, unless you have a VAWA application pending. Because with the T and the U, the waiver is the I-192. It's not a 601. Okay. I only have one more question I can answer. Hola, yo aplico para el PIP y me llegó la cita para las huellas, ¿qué sigue? Si llegó la cita por las huellas, sigue haciendo las huellas, pero la única cosa es que ellos no pueden tomar una decisión ahora mismo porque está pasando en las cortes. So, tenemos que esperar por octubre para ver qué va a pasar. Si el juez va a decir que no puede aplicar, o esto no es justo, o lo van a cancelar. Si eso pasa, no importa, las personas que tienen las aplicaciones pendientes lo van a perder o lo van a negar. So esa es la única cosa. Pero si tiene los huellas y dice que tiene que ir, que vayas. Porque si no coja los huellas, ahí you lose your right to continue with that application. Okay, I'm sorry. That's all the questions that I have today. If you have more questions about your legal status, I suggest that you call for a consultation. The 30-minute consultation, it's only $50. We can do in person or virtual. We prefer Zoom so we can see you. But if you have more questions and maybe you want to get back on the lives, we're here every day. Monday's a Labor Day, so a holiday, so we're not going to be here. But we're here every day around this time, around 4 to 4:30, answering your questions. I'm here every Friday. So sorry I couldn't get to all of the questions, but definitely come back or call our office at 571-583-0791 and schedule a consultation so we can properly advise you of what you're able to do in your immigration status. So thank you for joining, and I'll see you guys next week.